Welcome, everyone. We're glad to be able to get together here. Sorry we missed the June meeting, and it seems like our last meeting on Valentine's Day was years ago. So much has happened. When I try to remember what I was thinking at the end of February about how the year was going to play out, of course, I had no idea that we would have gone through anything like we have gone through. But the good news is that the Texas court system has weathered pretty well. I'm president of the National Conference of Chief Justices and chair of the National Center of State Courts. And so I've been working a lot with courts in other states. And everybody is beginning to come through it pretty well now. At first, New York was completely shut down. They don't have much electronic filing. And so they were relying on paper filings. And of course, it was an issue back then, whether that would transmit the virus. And so they were really struggling, as were most of the courts in the Northeast. Now they've come through it pretty well. And California's kind of gone up and down, Florida, the bigger states, some of the smaller states like Wyoming and Idaho and Montana and the Dakotas were gloating early on that they didn't have any cases, and then it hit them too. So it has impacted all of us, and we're working through it. Texas judges, I imagine most of them were like me on March the 1st. All I knew about Zoom was it was hurrying down the street. And now OCA keeps track of this, and there have been something like 500,000 remote hearings by Texas judges involving something like 1.5 million participants. So about 2/3 of the judges are using it. And it really has profoundly changed the way we conduct our business. And everybody asked me, is it going to continue on after the pandemic is gone? And the answer, I think, is almost certainly yes. And we'll see to what extent. Filings are down. They're down about 16% in the appellate courts. And a comparable amount in the trial courts. But the clearance rates are good, except in a couple of areas that we have a little concern about, but we're monitoring those. But otherwise, the courts are staying on top of their business. The appellate courts are completely caught up. The big issue out there is jury trials. We had about 9,000 jury verdicts last fiscal year. And so far this year, since the middle of March, we've had about 16, unless we got a couple in this week. But as of the start of the week, it was about 16. So we're about 4,000 or 5,000 behind. And that's a real problem. It may be possible to deal with a large number of those with virtual trials in the justice courts. We're kind of waiting to see about that. We've had one and it worked pretty well. So we're still kind of feeling our way and experimenting. Of course, we want the parties and the lawyers to feel as if justice is being done and their clients are not being prejudiced by efforts that we having to make to keep them safe. But it's just something we have to work through. And again, courts all over the country are doing the same thing. We're trying to expand jury trials some, but it's tough slogging. And so we've just got a ways to go. Evictions have mostly halted because of various programs, and we're working on other programs that we hope will aid eviction cases. Supreme Court has one that it's working on now, and we're not prepared to release it yet, but we will shortly. And we think it will help somewhat. Debt cases seem to be down in the sense that people aren't filing them, but we can't imagine that they won't skyrocket like they did last year before the pandemic. So we're concerned about that. Not just the number of cases, but the impact on parties and then the community around us. So lots of challenges. And we're anxious for the council to lead on these and other issues. Of course, we had the protests, and they continue. And so our good Public Trust and Confidence Committee has taken those to heart and made some recommendations for us today on those. So we have lots of different issues to concern ourselves with, and then wondering what the session will be like. And even where it will take place if things don't get a little better. As you can see, an enormous amount of work has been done by the committees, and they've got great reports and strong resolutions that we'll look at today. These form the basis for our legislative recommendations and our work across the street. And we began to draft legislation on these resolutions in the weeks ahead to be sure that we're pre-filed and ready as much as we can be for the session. So this is an important meeting for us in that we're preparing for that. The meeting's being webcast this morning live, and of course it's being recorded as always, and there'll be a copy archived later. And speaking of jury trials, Judge Miskell was really a leader in helping to try to move us in the direction of planning good, solid, safe jury trials. And for her work and her other contributions to the state and to the council, she received the 2020 William H. Rehnquist Award for Judicial Excellence. It's the highest honor that the National Center for State Courts gives a state court judge who demonstrates the outstanding qualities of judicial excellence, including integrity, fairness, open-mindedness, knowledge of the law, professional ethics, creativity, sound judgment, intellectual courage, and decisiveness. That's a mouthful, but it barely pays honest tribute to Judge Miskell, who has really been a big contributor for us in the Texas judiciary. She would have gotten the award from Chief Justice John Roberts at a dinner in the Supreme Court's Great Hall in November, right before Thanksgiving. But the Supreme Court is closed, as you may have heard, except for special events and special ceremonies like the one yesterday paying tribute to the passing of Justice Ruth Bader Ginsburg and the family gathering that they had there. Very moving. And then it's been open to visitors who are coming through to do the same thing. So we're working on an alternative plan for Justice Miskell, and the chief has agreed to at least meet her at McDonald's at some point and celebrate her award, but we'll try to do better than that. But congratulations, Emily, and we're honored to be part of the council with you. Now I ask David to call the roll.
Chief Justice Nathan Hecht.
Here.
Presiding Judge Sharon Keller.
Here.
Justice Bill Boyce.
Here.
Mr. Kevin Bryant. I see he's on. Mr. Bryant, if you're speaking, we can't hear you. Mr. Bryant is on but muted.
Okay.
Ms. Clayton? She's present as well.
Here.
Senator Brandon Creighton, Mr. John Gamble is also present. I think he's muted right now. Judge Bill Gravel here as well. Representative Jeff Leach.
I'm here.
Judge Emily Miskell.
I'm here.
Judge Kelly Moore.
Here.
Judge Valencia Nash.
Here.
Judge Kathleen Person.
Here.
Ms. Rachel Ratz.
Here.
Chief Justice Sherry Raddick.
Here.
Mr. Ken Sachs.
Here.
Justice Maggie Sawyer.
Here.
Representative Reggie Smith. Judge Ed Spillane.
Here.
Judge Vivian Torres.
Here.
Mr. Evan Young.
Here.
Senator Judith Saffarini.
Present.
Chief, there's a quorum.
Thank you. You've had an opportunity to see the minutes of the February 14 meeting. Are there any comments or objections to approval? If there are none, the minutes stand approved. We'll hear a report from Jeff Burkhart at the Texas Indigent Defense Commission. Jeff?
Thank you, Chief. Good morning. It's good to see everyone, even if virtually. Updates for the Texas Indigent Defense Commission. The board met August 27th, really focused on two things. One was proposed legislation for the upcoming session, and the other was improvement grants to build new offices in Texas. As to the proposed legislation, the board approved 10 potential bills. Those bills will now, or potential bills will now go to the legislature to be filed, and we'll keep you posted on the progress of those. Most of them are relatively minor, many dealing with Article 1517 of magistration. The second purpose for meeting really was to focus on grants. The board awarded several improvement grants. 3 new public defender offices are going to be created because of those grants. Those 3 public defender offices will cover 10 Texas counties. So that includes Galveston, Kerr, Gillespie, Bandera, Kendall, Medina, Atascosa, Frio, Wilson, and Karnes counties. The board also approved funding for a new managed assigned counsel system to focus on mental health cases in McLennan County, as well as 2 indigent defense coordinators for Nueces County. Turning to TIDC's budget, like a lot of other state agencies, TIDC was cut 5%. That for TIDC for the biennium is about $4.7 million. Those cuts have come heavily from the admin budget, but also a good deal of that, $3.5 million, came in the form of cuts to grants to counties. So we're definitely dealing with that and doing the best we can. Last week, the Texas Indigent Defense Commission filed its legislative appropriation request. We have 3 requests. 2 are rider revisions, and the main request is estimated appropriation authority. This is the same thing we requested last session. Essentially, what estimated appropriation authority does is allow TIDC to spend any funds that flow into the Fair Defense account. So we're very hopeful for the session. We could certainly use the funds. As you all know, TIDC has made a lot of progress over the past 20 years. And we have still a lot of work to do, a lot of work when it comes to access to counsel and quality of representation. So we'll certainly keep you posted on that, and I'm happy to take any questions.
Questions for Jeff? Thanks, Jeff. That's a good report. You'll have in your materials also the director's report for the Judicial Council, and it's really a tour de force of the work that's going on throughout the Texas judiciary. It's not on the agenda to present, but any comments you want to add on that, David?
No, Chief, it's been a busy and crazy year. We tried to give you an overview of everything that's going on at OCA and other places throughout the judiciary. And I would just call your attention perhaps to the last section of the report, which talks about the response to the coronavirus. And there's a lot of good information there that might be helpful to you as well. And Chief, just for the record, I would want to show that Representative Reggie Smith has joined us as well.
Good.
Yes, glad to be here.
Great. Welcome.
Sorry I'm late.
That's
Thank you,
all
John.
right. Good. Thank you. We'll go to our committee reports. The first is the Civil Justice Committee. Chief Justice Raddick.
Good morning. First, I want to thank the staff at OCA. Without them, as you well know, Chief, we could not do that work. And I also want to thank the members of our committee, which consists of Senator Zaffarini, Honorable Bill Boyce, the Honorable Emily Miskell, the Honorable Vivian Torres, Representative Jeff Leach, Honorable Valencia Nash, the Honorable John Gimbel, Mr. Evan Young, Mr. Kevin Bryan, and Mr. Ken Sachs. The Civil Justice Committee met on November 8th. The February meeting was canceled for obvious reasons, and then we met again August 13th. We've got a nice proposal for you. I'm going to let David, if you will, present the details.
Thank you, Chief Justice Raddick. I'm happy to present the Civil Justice Committee's recommendations. Before we get to the recommendations, a little bit of background that the committee points out in its report. If you look at the data, court data pre-pandemic, it shows a civil justice system with year-over-year increases in case filings and growing case backlogs. Of special importance to the committee's recommendations, fiscal year 2019 data show that debt cases dominate the ongoing filing growth trend and have been significant in all court levels, but especially in our justice courts. The pandemic caused a major disruption in the civil justice system, and as filing trends return to normal, as the Chief Justice mentioned earlier, the courts may struggle to keep up with that caseload which we expect to be filed, especially in the area of civil debt. The committee focused its attention on 3 areas pursuant to its charge. One was enhancing access to justice in consumer debt cases. The second was to focus on online dispute resolution and where it might fit into the justice system in Texas. And the third was with regard to civil filing fee simplification and reform. The committee has for you a total of 13 recommendations. The first one is in the area of enhancing access to justice in consumer debt cases. And I'll just quickly run through them. And if you have any desire to discuss them further, I'm happy to do that. First recommendation is that there be rules adopted that would make the process of understanding and engaging in debt claim lawsuits more accessible through the use of a post-service letter and answer packet. Basically what this would do is that the Judicial Council, if the recommendations were adopted, would direct OCA to create a packet that would be sent to defendants after service. Part of the concern is that the default judgment rate in these cases is really high. And the thought was that this might help reduce that and engage more defendants in these cases. Both the plaintiffs groups have reported that having defaults in these cases are not beneficial. And of course, there are harm to defendants who don't answer their cases. So that's the first recommendation and sub-recommendation. Second recommendation is that there be rules adopted that would improve access to justice for unrepresented defendants by requiring courts prior to issuing default judgments and debt cases to send the defendant a notice explaining what the default judgment is and what its implications are. And again, TJC would direct OCA to create this notice packet. Again, this is meant to try to give defendants one more option to get engaged in their case, otherwise default judgments would be entered. The third recommendation is that the Supreme Court adopt a rule requiring debt claim plaintiffs to submit documentary proof to substantiate a debt, the amount owed, and the right to collect it. Judges over the last several years have made known to this committee, as well as other groups, that there are oftentimes cases where the documentary proof has not been submitted to the court. And so when the court is signing a default judgment, for instance, the court's not able to substantiate that that is a debt that is owed by that defendant and that the plaintiff has a right to collect it. And so the recommendation is that that rule be amended to require that documentary proof to be submitted. The next recommendation is that the Supreme Court adopt a rule requiring debt claim plaintiffs to demonstrate compliance with certain provisions of the Finance Code governing debt collection. There are 2 specific statutes in the Finance Code right now that deal with debt claim cases, but there's no requirement that plaintiffs demonstrate that they've actually complied with those when they're filing their cases. The next recommendation is that the Supreme Court amend two specific rules in the rules of civil procedure to better ensure that judgment debtors are aware of and can assert the protections available to them under the law. This would just be specifically providing more information to judgment debtors in these cases. The next recommendation is that the Supreme Court adopt rules governing the issuance of turnover orders, appointment of turnover receivers, and the mechanisms for challenging turnover receivers. Right now, there are no rules that govern these proceedings, and so there was concern raised that the lack of rules does cause problems and that the court should adopt rules. The report is and recommendations are silent as to what those should be, but that there should be some rules to govern that whole procedure and process. And the last recommendation in this section is that the legislature provide by statute a minimum cash exemption to ensure that families can cover basic living expenditures while still allocating the remaining funds to repay the debt. There are some statutes that exist, and I think there's actually a constitutional provision that enable families to retain a certain amount of money for basic living expenditures. But the statutory language is outdated. It refers to amounts that have been provided to the individual in cash or check, but doesn't cover direct deposits and other funds that might be in bank accounts. And so the hope here is to update that statute to provide that, to make it current with the way that most people are paid these days. That's it on the civil debt recommendations. I'll move on to the online dispute resolution recommendations, and there are two of those. The first is that the council adopt a rule implementing the Texas Online Dispute Resolution Policy Framework. That's a mouthful. But basically, there were several groups, including the Pew Foundation, the Access to Justice Commission, and others, who presented to the committee a framework that would help courts as they look to implement online dispute resolution. And the goal here is to ensure that as online dispute resolution is being implemented across the state in various courts, that it be done in a way that protects the rights of litigants in the courts, both plaintiffs and defendants, and that it provide a guidance for judges and courts who are looking to implement it. That framework is attached to the committee's report, but the committee did review that, and we're thankful to the groups who worked on that, and we think it would be a good framework to adopt. The committee also recommended that OCA implement a low-cost or free online dispute resolution platform throughout Texas so that parties in civil matters can access the judicial system better. If you're not familiar with online dispute resolution, basically this is a way that litigants in cases can asynchronously engage with each other and try to resolve their disputes. In states and nations around the world that have implemented online dispute resolution, litigants report being able to resolve their disputes more timely, efficiently, and with a very high customer satisfaction rate. Obviously, some counties may be able to do this, or some cities may be able to do this, but it's unlikely that a lot of our counties and cities would be able to do that on their own. And so the recommendation here is that OCA implement that statewide so that that platform would be available for litigants in all cases where it's appropriate. The last recommendation deals with the area of civil filing fee reform. I know that we have two state legislators on this call today who worked on the criminal court cost filing fee restructure. Both Senator Saffarini and Chairman Leach both carried a bill last session, which was very long and complicated, but which attempted to resolve constitutional and complexity issues with the criminal court cost system. The recommendation here is that that work continue on the civil filing fee area. There is some concern by the committee and by others that there are civil filing fees which might be unconstitutional in their application, and that in particular, the civil filing fee structure is very complicated and difficult to administer by our clerks and courts across the state. This recommendation is that the legislature simplify and consolidate the civil court filing fee system similar to the way it did with the criminal court cost system. I would point out, just for your understanding, that the recommendation in its detail details that should be done in a way similar to the criminal court cost consolidation, in a way that attempts to hold harmless all the state and local governments that receive funding from civil filing fees, as well as the programs that receive funding, in a way attempt to try to resolve those different issues. And that's the recommendations of the Civil Justice Committee, and I'm happy to answer any questions you may have about any of them.
Let me just add a couple of things. On the first set of recommendations regarding procedures in debt and other cases, the Supreme Court worked with the justice courts beginning in 2011 to a pretty broad rewrite, revisions of the rules of civil procedure affecting justice courts, which were adopted, I think, in 2013. And the procedure seemed to work pretty well. We had a great task force of judges and lawyers who are frequently in cases in those courts. And a lot of the changes were agreed to, and the ones that weren't were completely and thoroughly presented to the Courts Rules Advisory Committee, and I think resulted in a good product. But we also told the judges, as time passes, if we need to relook at these, please let us know. And last year, in the years since, we've gotten some comments from time to time. We might want to rethink this or that. But last year, we began to get more of them. And the Supreme Court decided last fall that it would reform the task force and get them to look at changes that might be advisable in the rules of civil procedure. We got waylaid by other work, and so that never quite got done, although it's very much on the table. But now with these changes with the pandemic, it's even more important to reconstitute that group and take a look. So we plan to do that and call on Judge Nash and Judge Sawyer to help us with that. We've also got a Justice of the Peace working group of 5 or 6 justices of the peace and lawyers from legal aid and creditors and landlords' perspectives, working with the training center to try to handle the peculiarities, the peculiar challenges of the pandemic. And they've been very helpful with that. So we'll resurrect that work here pretty quickly and see if we can't get some recommendations before too long. But it will be more, we'll certainly want to look at these recommendations, and then there may be some others as well. Any comments, other comments or questions for Chief Justice Raddick or David?
I have a comment.
Please.
Yes,
Senator.
my comment is regarding the fees legislation, that the bill that we passed last time regarding criminal court fees is far from perfect, because we had to include some fees that we intended to remove in order to get the votes to pass the bill. So as we look at the civil court fines and fees, we'll have to consider that too. That sometimes there are people who are really vested in a particular fine or fee that they want for a certain purpose. And so we need to keep that in order to get the votes to pass the bill. And that's just the reality of the legislative process. So don't think our bill is perfect.
Anyone else? Well, the committee has a report, and I believe its chair has moved the adoption of the report, which does not require a second. So we'll vote. And Senator Zaffarini says, hold up 1 finger for yes, 2 for no, and then I forget the rest of them. But 1 and 2 for now. So all in favor of the committee motion to adopt their report? Any opposed? Motion carries. And then they have a resolution as well. And again, a motion by the committee to adopt its resolution. Any discussion on that motion? All in favor? Opposed? Motion carries. Thank you, Chief, for your excellent work on this and all the committee members. These are very thoroughgoing recommendations. I was on a webinar with the Pew Charitable Trust organization earlier this week, and some officials from around the country talking about these debt cases. And I proudly told them about your recommendations and resolution, and they were glad to have glad to know what Texas was doing. So next we'll hear from the Criminal Justice Committee, Judge Kelly Moore.
Thank you, Chief Justice Hecht, and thank you to the committee members of the Criminal Justice Committee. I'd like to especially thank David and Megan and Kelly and the other staff at OCA for their help to the committee throughout the process. Our committee consists of Presiding Judge Keller, Judges Bill Gravel, Maggie Sawyer, and Ed Spillane, Senator Brandon Creighton, and Miss Rachel Rax. The first item that I'll talk to you about today are our bail recommendations. Those of you that have been on the council for a few years know that this is same song, third verse. And we're really hoping that the old adage about third time's a charm works. We'll be bringing more or less the same recommendations to the legislature related to bail reform that we've done on the 2 previous sessions. I'll tell you this from my new position as Executive Director at the Lubbock Private Defender's Office. I've seen this issue from another side over the past year. And when you add to that the challenges of the pandemic, it just makes it, at least to me, more and more clear how important these bail reforms are. I think bail reform is one area that'll tie into the last resolution that was sent out to us this morning about confidence in the judiciary and implicit bias. I think it all ties in together. And I think that bail reform will help with the many areas of distrust in the judiciary by a large amount of people that seem to be evidenced right now. But in any event, these are very similar to our recommendations from the 2 previous sessions related to bail reform. The primary change this year is that instead of recommending a more broad scale ability for pretrial detention without bail, we're limiting our recommendations to cases of violence and violent crimes. And we're hoping that that'll make that area more palatable to the legislature and to the other stakeholders. Our recommendations primarily are that we recommend that a validated pretrial risk assessment be required before any defendant is taken to his 1517 hearing in front of a judge or a magistrate, and that the other highlight is that we recommend that there be a presumption of pretrial release without money bail or cash bail. And this is that big change, the big change to the system. But we recommend that also that the judges be permitted to still use all of the bail options that are available today, but that we start trying to work a presumption in favor of pretrial release without the posting of money bail. In order to accomplish this, we recommend that the legislature should provide funding to ensure that there's availability of pretrial supervision. If people are going to be released without a point of contact with the traditional point of contact of a bail bondsman, there has to be a way to communicate with them and supervise them pending their trial or disposition of their cases. The rest of the recommendations I'm not going to go through in detail related to bail, because they are the same ones that we've presented before, and they relate to the collection of data, the providing of education for the judges, and the giving the Court of Criminal Appeals authority to make rules that will facilitate the bail issue. That takes care of the recommendation on bail. Our next recommendation relates to youth in Class C misdemeanors. This is another one that made it to the legislature. Last time it was actually came as a recommendation from the council's prior Juvenile Justice Committee. And the bottom line is in that non-traffic Class C misdemeanors often result in criminal convictions for youth in the justice system that can hang around with them for a long time and come up with a lot of adverse consequences in the future for them. And the recommendation is that the legislature should amend current law to allow for the diversion of youth charged with non-traffic Class C fine-only offenses and divert those from the criminal justice system. This has already been done in a wide area of things such as truancy and other areas where the council has taken a lead in getting some positive changes, and this is another one of those changes. It went well in the legislature last session, but it was in the end, it appears it was just too complicated, the bill, and the stakeholders are working on making it less complicated and trying to get it to, it's a good bill. Very few arguments against the merits of the bill, and the stakeholders are working on trying to get that in a better form to present to the legislature. I'm going to skip mental health for today because at our last meeting that we had, Justice Bill Boyce made a presentation from the Mental Health Commission, Texas Commission on Mental Health, and he's going to give you some information about that today. But I will say that the committee adopted and wants to recommend that the recommendations from the commission be sanctioned by the Texas Judicial Council. Our final area was in grand jury and jury reform. And this is the only time this morning you'll hear me say that the pandemic prevented us from doing what we needed to do. It's a very big issue. Back in our February meeting, we had actually heard reports from Shannon Edmonds of the TCDAA and Grant Shiner of TCDLA. It's a very robust issue, and it has a lot of good there's a lot of good area out there where we think that in the future the council could make recommendations to update, particularly the grand jury process, which has had very few changes in many, many years. But we need more information to do that. And so we ask that we be permitted to carry that over and continue our work on that. And that completes my report. I'd be welcome to answer any questions. Be glad to answer any questions if anybody has them.
Questions for Judge Moore? Yes, Senator.
Yes, my question is regarding any legislation that had been considered by the legislature before and failed, and you are recommending that we file anew. What changes, if any, were made in that legislation?
The bail legislation was mainly about the constitutional amendment that would be required to have pretrial detention, which we only have in very limited circumstances now. And it was going to apply to a wider range. David, could you chime in and tell Senator Zaffarini the exact change on that?
Sure. So the previous recommendation in the previous bill would have permitted something that's not well known to the public is that judges don't have the ability, except for very, very limited situations, to deny bail. So if someone has enough money, they can get out of jail, even if they're charged with the most heinous or serious crimes. The council's recommendations in previous sessions have been that judges have the authority to deny bail in any case if they determine that the defendant is a risk to the public for reoffense or risk of flight. And there's been some concerns raised that that's too broad, and that we should limit that to only allowing denial of bail in violent offenses if the risk of flight and the risk to the community is large. And that is what the change in the recommendation is. Just so you know, the legislation we're talking about has passed both houses at one time, just not the same session. Session before last, it passed the Senate. Last session, it passed the House, but it ran out of time over on the Senate side this last time. It just came over at the last minute and didn't get a hearing. In the previous session, it passed the Senate, it passed out of the House committee, and then it did not get on the calendar on the last day, and they ran out of time there too. So I mean, obviously there's a lot of chatter around bail reform. Quite frankly, some of the chatter about what bail reform is not what this council is recommending. This council is recommending primarily through these recommendations that judges be given more information with which to make bail decisions. Most judges, as you know, don't have any information about the risk of the defendant when they're making bail determinations. And so this council's recommendations speak to that. So a lot of times people misconstrue what the council's recommendations are, but that is what they are, is that the council have that ability. But the ability to deny bail is a big piece of this recommendation. And so that's been narrowed in this proposal. On the Class C misdemeanor youth in Class C, the change to that was that bill actually passed on the local and consent calendar in the House. That tells you how non-controversial it was, but it did not get a hearing in the Senate. It came over fairly late in the session and did not get a hearing in the Senate. And as Judge Moore pointed out, it was complicated. Just the way it was written. I think the bill was 50 pages long. It was fairly complicated to read. And so the stakeholders, we worked with judicial groups who work in the justice courts, as well as prosecutors and defense attorneys and others on this last session. And those groups have committed to basically reworking that proposal and working with legislative offices to make that simpler. So those are the two changes that have been made to the legislation that would be proposed, and the recommendations are tightened. The other thing I would say is it is important on the Class C youth one. Last time your recommendation was that they be that Class C offenses against youth be basically decriminalized and moved to the civil system. And this recommendation does not say that. It says they be diverted from the criminal justice system, which is what the ultimate proposal ended up being last time. So that's a key distinction I want to point out. And there was some objection from the justice and municipal court groups last time to making them civil or decriminalizing them. And so this does not say that. It says to divert them. They would ultimately be criminal if they don't comply, but they would originally be diverted from the criminal justice system.
Didn't DPS also have some objections?
I'm not aware of any objections DPS had to the juvenile Class C proposal. There were some other legislation that we worked on where there were some concerns, but I'm not aware of it with this specific proposal.
David, I apologize. What is the proposed standard for a judge to deny pretrial release?
It would be clear and convincing evidence of risk, high risk to the community for reoffense or high risk of flight. But it's similar to the federal standard for denial of bail. It is clear and convincing evidence. And how much? And I'm sorry, the way the proposal, the detailed proposal reads is that there be a fairly significant due process provisions written into the law that, let's say, an original magistrate found clear and convincing evidence to deny bail, that decision would be immediately reviewed by the judge of the court where the case is assigned, because sometimes it's not that judge who's making that determination, and that there be an ability to have that reviewed even further every so often afterwards, similar to the way we do juveniles.
So go ahead. I'm sorry.
Go ahead, Representative Smith.
Representative Smith, go ahead.
In the federal system, before you have the detention hearing, is what they call it, their pretrial court staff put together a packet of information, a history. They do an actual interview with the defendant and that sort of thing. And I mean, it's fairly work intensive. Does this proposal contain some vision as to what that, if any of that, what it would look like?
Yes, Representative Smith, the number one recommendation of this committee is that every defendant be screened with a validated pretrial risk assessment. It's a little bit different than the federal system. The federal system uses an interview-based risk assessment where they actually interview every defendant. And this is a non-interview based risk assessment is what we've recommended, which would be less work intensive by the jurisdictions, because we understand that 254 counties, it's not going to be possible to staff up the way the federal courts do that. And there are validated risk assessments which do this without requiring the interview of the defendant, that give judges good information about the risk of flight and the risk of future criminal activity.
And do we have an idea as to what the expense of that would be for a defendant case?
The OCA, in the recommendation, OCA is recommended to, in the last legislation, OCA was required to promulgate this and make it available to the counties free of charge. And I think OCA's cost was $600,000. We actually have a funding source that doesn't require general revenue to do that. So we could, and we have a sort of simple version of it right now that could be used. It's just a little more work intensive. There would be a requirement that someone at the local level collect some, enter some basic information, like what is the defendant charged with, what's their date of birth, a few key pieces of information. I think there are 7 fields that have to be entered. Some of those can be automated and pulled from state systems, but there would be a requirement that there be a few pieces of information entered by local officials. So someone at the jail, a pretrial officer, somebody on the court staff, and we would let local jurisdictions figure out how to do that. But the goal is to make it as little work intensive as possible for local jurisdictions, because we realize the capacity is not there to do that, but still get the judges information to be able to make the right decision.
Thank you.
Other questions?
Judge,
Chief, I just wanted to,
Okay.
I'm sorry.
go ahead. Go ahead, Judge.
Oh, thanks. I just wanted to say I'm glad to see that the youth diversion is back on there. I think that's really, really important. So I'm really glad that Judge Moore and his committee is taking on that task, because that's really one of those important things that we need to address.
Mr.
Your
Sykes?
Honor.
Yeah.
I just quickly, when we say diverting youth in this resolution, are we talking like in terms of the truancy cases would stay in the school district control, or would it go to this a civil court, or how would that be handled?
Judge Moore, with your permission, I would answer that.
Go ahead.
So the way that works, Mr. Sachs, is that the proposal, I mean, obviously we're working with the groups to actually get the language for the bill, but basically the way it was proposed last time, and I believe the vision here still is that number one, these cases would stay with the justice and municipal courts. I think there's a strong feeling among the committee and the stakeholders that the justice and municipal courts do a great job with these cases, and that the goal is to make it where they have tools still available to them to address these. The key piece would be that in the juvenile system, for instance, which if you're charged with a higher level offense, a class A or B misdemeanor or a felony, you get all these different opportunities for diversion. So you can have sort of an informal diversion process where the case never gets filed. You can have even a formal diversion where the court says, if you comply with X, Y, and Z, we're gonna not prosecute you. In the justice municipal courts, that does not exist. And so the goal with class Cs, it does not exist. And so the goal is to basically extend those similar provisions that are afforded to the same kids who are charged with higher level offenses to class Cs. But ultimately, if the child, just as in the juvenile system, if the child does not comply with the diversion program, that they could still be prosecuted in the justice municipal courts, but they would be given the opportunity to be diverted first, so that they don't have all the negative consequences that come with conviction, similar to the way they are in a juvenile court.
Like a pretrial diversion program. Okay.
Maybe there was a pre-filing option. Even an officer on the street could do the diversion similar to the way they do in juvenile cases. So the officer at the street could divert them. A case manager at a court could, the judge could. I mean, there's multiple opportunities for diversion, and it would just set up a framework where the local jurisdictions could decide exactly how they want to, which one of those they want to use, but they would provide judges tools to divert those cases.
Excellent. Thank you.
Other questions? Comments?
I do have a question.
Yes.
I just have one quick question. And this is great because the tools, we need those tools at the municipal courts level. My question is, at the county level, they collect a lot of information that we don't have access to. And I don't, it would be good, or are we looking at seeing, a way to get that information over to the municipal or the justice courts, so that when we have overlap of the guilt in one setting that could help us. Does that question?
You cut out a little bit there.
Understand my question?
Yeah,
Sure
you cut out there a little bit, but I think I understand your question, which is making sure the information is shared whenever a child is multi-involved or multi-system involved, I think is kind of what you're speaking to. And one of the things that was in the bill that was filed last session, which I think was really helpful, was a way to try to get juvenile case managers to be able to be used in more jurisdictions. Because right now, just the way the statute is, it's hard to get one set up and to get the funding available for them. And this would have expanded those options. And I assume that will stay. And what those juvenile case managers do is they act like, in a sense, like juvenile probation officers at the juvenile level, where they can gather information about where the kid's involved, whether it's multi-system involvements they have, what the situation is, what's the situation with school, and get that information and try to provide that information to develop a plan that would work for the child. And so the goal is to get that same type of information to the justice municipal courts. And if you're in a rural jurisdiction like Judge Sawyer, under the current law, it would be almost impossible to ever have that. But the goal here was to think about regionalizing some of that, providing additional funding sources where local jurisdictions could have that, just so there's sort of someone that's working with kids that doesn't have to be the judge in the case. So that was the goal, try to get all the information there, get all the resources there available to those courts.
Well, that's right on, because I have 2 case managers and I couldn't do.
Great.
Other questions? Well, the committee has a report and a motion that we adopted. So any further discussion of the report? Then all in favor of adopting the committee report? All opposed? Then we have 3 resolutions, one on bail, one on juveniles and Class C misdemeanors, and one on mental health recommendations. And we'll save the last one till we hear from Justice Boyce a little later on the agenda, but we'll take up the first 2. So there's a committee motion to adopt the resolution on pretrial release and bail. Any discussion on the motion? All in favor? Opposed? The motion carries. Then we have a motion to adopt the resolution on the juvenile and Class C misdemeanors. And it's a committee motion as well. Any other discussion on that motion? Then all in favor? Opposed? The motion carries. And as I say, we'll take up the last resolution here a little later. And move now to the Public Trust and Confidence Committee, Judge Ed Spillane. Judge.
Thank you, Chief Justice. And I as well want to thank our committee members and OCA staff. Our committee members are Honorable Sherry Raddick, Vivian Torres, Maggie Sawyer, Senator Zaffarini, Mr. Ken Sachs, Ms. Sonia Clayton, and Rachel Rock. And we met twice, January 23rd and August 28th. We have essentially 3 resolutions that can be grouped in 3 different groupings. Our first resolution is on remote proceedings. And as the Chief Justice just mentioned, and I think most courts are aware, the ability to use Zoom and operate our courts remotely has been a tremendous help in terms of providing access during the pandemic, and really was based, happened very early on in mid-March with the Governor Abbott's disaster declaration, an emergency declaration for the state. I think we've had 26 emergency orders. I've lost count, but the first emergency order did 2 key things. The order suspended our deadlines and also allowed us to do remote proceedings. What a lot of courts may not be aware of, though, is that these emergency orders are very much dependent on the governor's emergency declaration under Section 22 of the Government Code. Also, that came out of our committee a couple of years ago, and thanks to Senator Zaffarini's bill, we passed a bill allowing us to meet remotely. But this legislation was really keeping in mind a Harvey type of situation, not necessarily the unique pandemic. And as the Chief Justice mentioned, we've had 500,000 remote hearings, 1.5 million participants, 1.1 million hours between March and September. And we really do stand, and this is my opinion, but we do stand unique as a state in terms of the depth of remote proceedings, but also the swiftness. Very early on, mid-March, OCA jumped on it, got us the Zoom licenses, and judges and courts have run, and participants have run with the remote proceedings. But one thing that we've discovered is that these remote proceedings may have helpful benefits to courts post-pandemic in terms of allowing access to the court. So we are making the recommendation, the resolution, that the legislature and Texas Supreme Court should remove any barriers to continuing remote online court proceedings and court innovations developed as a result of the COVID-19 pandemic. As I mentioned, right now the emergency orders are very dependent on the governor's declaration. And once that's suspended, and we hope for that day, when we get to that point, a lot of our ability to do remote hearings will disappear without legislation. And we have discovered that it's not only allowed increased access to courts for litigants, lawyers have appreciated in terms of travel. We've seen an increase in ability to use interpreters. There are a number of ways in which being able to conduct court remotely can benefit courts post-pandemic. And in June 2020, OCA did a survey of 3,000 Texas attorneys, and they overwhelmingly have supported the use of remote hearings at this time, but also see the positive benefits to remote hearings post-pandemic. It's the committee's belief that these hearings will never replace in-person proceedings, and they shouldn't. But in terms of access to justice, accessibility, efficiency, we would like to have the ability in certain situations to be able to use the remote software and the post-pandemic. So that's our first resolution. Our second resolution has to do with civic education. I think many of us are aware, especially if we have someone who's gone through high school, just how little our high school graduates are aware of civic education and government, particularly when it has to do with the third branch of government. The American Bar Association did a study, and only half of America can identify the 3 branches of government. Our committee did a 2018 public poll, and 52% of the respondents said it was up to the person accused of a crime to prove his or her innocence. Our committee has worked and the council has heard from Senator Zaffarini about her, the program that she's been very much a part of called Access to Justice, Class in the Courtroom. It's within that idea that we want to build a partnership with the Texas Civic Education Coalition. It was formed in November last year to provide for Texas students responsible, informed participation in civic life by promoting nonpartisan education initiatives. So our recommendation is that the legislature should amend state law to require a comprehensive civic education that results in informed and responsible civic engagement for Texas school-aged children. And I won't go through all the details of the Texas Civic Education Coalition, but they want to, their recommendations are not just general, they're very specific in terms of knowledge, skills, attitude, and civic behaviors. One of the recommendations that I particularly think that the council would appreciate is they would like to mandate a student-led but curriculum-based project in 8th grade and in high school, effectively demonstrating understanding of crucial civic behaviors. They want the TEA to infuse civics education to other disciplines by providing content-rich, nonfiction civic texts in English language arts testing where reading and writing prompts are used, and also increase to 25% during every 5 years, the mandated education that teachers go through, have 25% of their continuing education hours be specifically on effective teaching of media literacy, simulations of democratic processes, civic practicums, and guided classroom discussions of current events. So I think this resolution is another step in the council's support of good civic education in Texas. And finally, we have 2 recommendations, but our 3rd resolution has to do with judicial education. The Texas Court, and this is a recommendation to the Texas Court of Criminal Appeals. The Texas Court of Criminal Appeals is responsible for adopting rules for programs relating to the training of attorneys, judges, justice of the peace, district and county clerks, law enforcement officers, law students, and essentially every participant involved in our courts. And in the past, the council has made recommendations on specific training. Our first recommendation is that the Texas Court of Criminal Appeals should require judges to obtain additional training on implicit bias. Implicit bias has been part of the training since 2001, when the Texas rules of judicial education were amended to require judicial entities to provide training in issues related to race, fairness, ethnic sensitivity, and cultural awareness. However, unlike family violence training hours, there's no requirements that judges have to obtain a certain number of hours on implicit bias. Given the way the seminars that we go to, it's very easy for a judge to possibly skip the training that may be part of it and choose another option. So in light of the national events that the Chief Justice mentioned, and in an effort to continue our dedication to continuously work on improving public trust and transparency, we recommend that judges be required to obtain training on implicit bias annually. Our second recommendation is that the Judicial Council create an advisory committee on the council to assist the council in its focus on judicial training, community engagements, and developing judicial summits. We have a strong history of public engagement. The Chief Justice has mentioned at numerous councils before. In 2016, when the Texas Court of Criminal Appeals and the Supreme Court of Texas hosted a summit called Beyond the Bench in Dallas, Texas. We also in 2018 conducted a public and confidence survey. And also in 2019, we were one of 6 states chosen for a public engagement pilot project sponsored by the National Center for State Courts OCA has been actively involved in that, and we've held 3 engagements last year in Alpine, Brownsville, and Houston. Recognizing the efforts of all those efforts, the committee recommends that the council create an advisory committee to focus on judicial training, community engagement, and developing judicial summits. It should be comprised of members of the Texas Judicial Council, judicial officers, advocacy groups, attorneys, community members, law enforcement, and any other members necessary to its mission. So it'd be a committee. This task is way too great and should involve a more diverse group than just our council. And that is our final recommendation and the report.
Thank you, Judge. Questions for Judge Spillane? Comments?
I have a question, Chief.
Yes.
Okay. I am so thankful to the committee for doing all this work, and I think they've come up with some great ideas. But what I understood Judge Spillane to say was not exactly what I read in the second resolution, which was to increase training and implicit bias. But I thought the resolution left it up to presumably the new Judicial Advisory Committee and the Court of Criminal Appeals to hash out the details of that.
And the Chief Justice is correct. I mean, it requires the judges to obtain additional training, but it does not. The resolution does not specify exactly, the number of hours. But we would. I think that's all it says. But we hope that judges, aren't able to opt out. It's part of our recommendation.
Right, I'm totally in favor of it. I just thought that this was a perfect issue to refer to the new Judicial Advisory Committee to look at more deeply.
Yeah.
Thank you.
And I don't disagree. I think that's true.
Other questions or comments? Well, I'll just say that as I said at the beginning, I think online proceedings are here to stay and will make a big difference in various areas of our process, such as pro bono and legal aid cases. It'll just make it a whole lot easier for people to participate. And those communities are already working on ways that they can facilitate that. And on civics education, I have spoken to the Commissioner of Education, and there's quite a bit of, there is a lot of expertise in the community, in the public generally, about providing better civic education. It's just not going anywhere. So we hope we can push it a little harder. The Commissioner of Education said he's for it, but it really is a question for the board to resolve. But the lawyers and judges have known for a long time, ever since Justice Sandra Day O'Connor started telling us that this is really a problem. And as we become more aware of it, it's just a bigger and bigger problem. So we'll try to push on that a little harder. And the training and having a focal point, I think the council is the right place to sort of be a clearinghouse for criticisms of the justice system, the way it's operating, and so that we can explore them, examine them, get to the bottom of them, be sure that the ones that don't have any merit are at least responded to, and the ones that do, we can use to make improvements. I think everybody thought the Beyond the Bench meeting a couple of years ago was time well spent. So those are the recommendations. Any other questions of Judge Spillane or comments on them? Then they have a report, and the committee motion is to adopt the report. Any further discussion on the motion? All in favor? Opposed? They also have three resolutions. The first is to remove barriers to online proceedings continuing after the pandemic. Again, a committee motion. Any discussion on the motion? All in favor? All opposed? The second motion is to improve and work toward a more comprehensive civic education. Any discussion on the motion? All in favor? Opposed? And finally, a resolution, a committee motion to adopt a resolution on judicial training on implicit bias and other like issues. Any discussion on the motion? All in favor? All opposed? Thank you. Motion carries. And that, I think we have three other resolutions, but we'll hold them for just a minute while we get a report from the Data Committee. Judge Gravel.
Morning, Chief. It is good to see you, sir.
You're broke. We're not hearing you, Judge.
Judge, we could hear you when you were close to the mic like that, but when you leaned back, we couldn't hear you.
Can you hear me now, David?
Yeah.
Good. I'm sorry, Chief. I am expert at being a county judge, but I am not an expert in computer technology. It is good to see all of you, and it is good to be seen by you, our committee. We have some wonderful members: Creighton, Clayton, the Honorable John Gimble, Mr. Young, Judge Persons, Judge Nash, and of course the nationally recognized on our committee. And we do look forward to going to that recognition. Data Committee has been, hear me, David?
You're breaking up.
There, David?
We can hear you there. It just
Barely.
cuts in and out. You just keep talking.
I'm going to keep going. Good. So our committee report, we had a meeting on February the 12th, and Mr. Slayton made a wonderful presentation to us about case level data, and we were able to hear that report as well. We received a report from the National Center for Courts, giving us an update on the National Open Courts of Data Standards project that they're working on, which actually includes 300 data elements, from criminal to civil to family to juvenile delinquency, child protection, probate, as well as traffic, parking. Since that time, the National Committee has met and approved drafts that will be met in April for that. Our committee has been working to review and to discuss the internal drafts that have been prepared by Angela Garcia there at OCA, the Chief Data Officer, and we're working closely to bring something forward. She's been working on analyzing the criminal and the data elements, and which elements are currently being collected, and developing recommendations what the Judicial Council should be collecting. I would remind all of you that the Data Committee is a long-term committee with no recommendations at this recommendations.
Okay. Thank you, Judge. Any questions for Judge Gravel? Thank you, Judge, for your report. And the last committee is the Strategic Vision Committee. Justice Bill Boyce.
Thank you, Chief. The Strategic Vision Committee met in February. The committee members are Chief Judge Keller, Judge Kelly Moore, Judge Kathleen Person, Senator Zaffarini, Representative Leach, and Mr. Kevin Bryant. And we began the process of mapping out a procedure to develop a strategic plan for the Texas judiciary, identifying themes that will be central to that undertaking. And those include promoting access to justice, protecting children, families, and communities, promoting judicial branch excellence and innovation, enhancing professionalism within Texas courts, and promoting public trust and confidence. Many of the things that we've already touched on at today's meeting. The next steps for the committee will include developing a survey for external and internal stakeholders to explore visions for the judiciary, deciding the length of the strategic plan or the strategic vision, and working towards hosting a summit for the stakeholders involved when we get a little bit further down the road. And that provides an overview of what the committee has been doing these past months.
Any questions of Justice Boyce? The Criminal Justice Committee, as part of its report, has recommendations on various mental health issues, a number of them, and they're laid out in the Criminal Justice Committee's report and made part of a resolution encouraging legislative action on them. So you've had an opportunity to see the report, and there's a motion by the Criminal Justice Committee to adopt the report and also a motion to adopt the resolution on the recommendation. So any discussion on the motion to adopt the report? All in favor? All opposed? Any discussion on the motion to adopt the resolution on the mental health recommendations? All in favor? All opposed? The motion carries. Then we have three other resolutions, I think. One on adequate court funding, one on civil legal aid, and one on funding for indigent defense. David, you want to comment on those?
Sure. So these are three resolutions that the council typically adopts prior to the legislative session, and they're fairly broad, and they all speak to funding priorities for the branch. The first one, the adequate court funding, is the broadest of the three, and it basically speaks to both the legislature and county commissioners courts, with the council's encouragement that the legislature and county commissioners courts ensure that the judiciary at the state and local level have the resources it needs to continue its core function and mission. This resolution speaks specifically in the time of a budget crunch to making sure that the judiciary has the funding it needs for critical core functions. So there's nothing really there specific. There's no specific request, but that is addressed there with a few other items. There's no specific money items. They're just sort of a broad policy statement. The second one is with regard to civil legal aid. As you probably know, basic civil legal services is a key function of funding that's provided to the Supreme Court and to the Texas Access to Justice Foundation that then gets distributed to various legal services providers throughout the state. As you probably know, funding over time has decreased from the interest on lawyer trust accounts, or IOLTA. When interest rates are zero, that's not generating much revenue for legal aid, and the state has stepped up in previous sessions in ensuring that there is adequate funding to do that. There is some federal funding that comes for legal services, but the state of Texas has been very proactive in ensuring that there's legal funding. This basic civil legal services is for things such as domestic violence, victims of domestic violence, sexual assault, other types of critical needs that can be addressed, and there's income eligibility requirements and other things. And so obviously the pandemic has exacerbated some of these issues. The Supreme Court has made a request for funding right now for some additional funding to support those needs. It's being considered by the legislature and leadership of legislature and the governor's office, but then also has made a request in its appropriations request for additional funding ongoing to support legal aid. So this resolution provides support for funding for legal aid generally. And the last one is with regard to funding for criminal indigent defense, similar to legal aid. A lot of the funding, or I shouldn't say a lot, some of the funding for the criminal indigent defense system in the state is provided by the state. The majority of it, about 90% of the funding, is provided by local governments. This resolution is actually pretty specific in that it supports the two requests from the Texas Indigent Defense Commission that Jeff Burkhart talked about earlier. One is to have estimated appropriation authority. To be clear, what that is there is money that is collected from criminal court costs and other sources and placed into a fund that can only be used for criminal indigent defense. But right now, the commission doesn't have the authority to spend all of that money that's collected there. The legislature basically only has allowed them to spend some of it, and then the money just sits there being unspent. All the while, the counties and cities or counties are supporting indigent defense. And so this resolution speaks to giving estimated appropriation authority to the commission and giving it the authority to use its revenue that's provided to it in a way that the commission board members feel is most appropriate. So those are the three resolutions. Again, these are typically passed by the commission, but these are the last two are a little more specific to the current needs of both legal aid and criminal indigent defense.
Any questions for David on these resolutions? They're kind of our standard resolutions. So is there a motion to adopt the resolution on adequate court funding?
So moved.
Second? Any further discussion? All in favor? Opposed? The motion carries. Is there a motion to adopt the resolution on civil legal aid?
So moved.
Second?
Second.
Any further discussion? All in favor? Opposed? Motion carries. And finally, is there a motion to adopt the resolution for funding of criminal indigent defense?
So moved.
Second? Any discussion? All in favor? Opposed? Motion carries. Thanks very much. Now we have two items of new business and we'll be done. First is the judicial firearm admonishment rule. And Brandon Bellis is going to present this to us, I think. Brandon?
Thank you, Chief. Good morning, council members. OCA has produced for the council's consideration two model admonishment forms, one oral and one written, for use in the firearm admonishment required by the council's new administrative rule that went into effect at the beginning of this month. To quickly recap the rule, a trial court must now inform a person that that person is ineligible under state law to possess a firearm or ammunition when by entry of order or judgment, the person becomes ineligible to possess a firearm or ammunition. It's a lot to spit out. Under the administrative rule, the admonishments must perform two key actions. They must inform the person of that ineligibility, and they must clearly inform the person that possession could lead to additional charges against the person. The model admonishment form contains a sample paragraph that touches on that ineligibility admonishment and the risk of potential charges for possession. It contains information about firearm as a legal term and refers to the written form on this issue and urges an admonished person to contact counsel should that person have questions about the laws surrounding that ineligibility or how long that ineligibility might last. The model admonishment, the written model admonishment covers a bit more ground as it's meant to be handed to or sent to an admonished person. There are cases where a person may not be present to be orally admonished. It, like the oral admonishment, touches on ineligibility to possess and the risk of possession and urges the person to contact counsel if they have questions. It also contains a reference to Penal Code Section 4601's definition of a firearm and provides a few statutes that might be of interest to the admonished person. In drafting the form, that we didn't have any intention to imply what statutes would apply in every case. If anything, it was an educational reference point, and that's why we've included it below. On both forms, we've included a notice to courts that the form is a model and that they retain the discretion to alter the admonishment as they deem necessary, so long as they comply with the rule. That's a quick recap of it. I'd be happy to take any questions if there are any, and if not, that would conclude my presentation.
So the council will recall that we've already adopted this rule and published it, and it calls for the drafting of both the oral and the written statement. This all grew out of the aftermath of the shootings in El Paso, Odessa, and Midland, and Governor Abbott's roundtable discussions and the safety plan back in last September. So this is simply the last step in trying to provide specific language. Any questions, Brandon?
I was just going to add, I was skimming the references to some of the statutes that would trigger this. One of the issues in, for example, family law is the form TROs that can be automatically in place in a family law case without an affidavit do contain two items that under the federal domestic violence gun ban make you an ineligible person. And so one thing I might suggest is, it gets kind of technical, but you might reference that section of Chapter 6 of the Family Code just to help judges. And then the other thing I would just request is, we had a lot of confusion in my county about what to do about this. And so I don't know the appropriate way to maybe just alert the Center for the Judiciary or something that to help us with more judicial education in implementing it, because this has been met on the ground with a lot of practical confusion.
David?
I would add, Judge Miskell, that the rule actually does, I think, contemplate for training on this issue. So that's certainly something that can be looked at.
Good point. And the statutory, we should contemplate that the statutory references might have to change as statutes come and go or added. We would want to keep it up to date, just to make sure that we're giving judges all the help we can give them. Thanks, Judge. Anybody else? So we'll entertain a motion to adopt the oral and written statements that have been proposed.
So moved.
Second?
Second.
Any other discussion? All in favor? Opposed? Motion carries. Is there any other business for the good of the order?
If we do have one more agenda item on
Okay.
confirming the electronic vote that you all took.
Oh, yeah. I'm sorry. I looked over that. Sorry. Yes. There's a statute last session requiring that a protective order registry be established. I think Senator Huffman and I don't remember who else.
Chairman Landgraf.
Yeah. And so that was actually like quite a bit of work. After the proposals were drafted by OCA, we ran them through the advisory committee because there are a lot of privacy issues and reputational harm issues and people saying things to malign others. And there's just a lot of issues. So the advisory committee spent 2 sessions on it and a couple hours each time talking about it. And then OCA took all that and has established the registry and the protocols for the registry. And then the ransomware hit us on May the 8th. So that on top of the pandemic slowed the OCA down and they had to focus on other things. So we polled the council earlier and asked for permission for OCA to delay the establishment of the registry from June the 1st till September the 1st. And we now just need a motion to confirm the electronic electronic vote that we took earlier, just to make sure the council was in favor of that. So any other, any discussion about that? This would just confirm the vote the council already took electronically.
I'll make the motion.
Second?
I second that, Chief.
Any other discussion? All in favor? Opposed? Motion carries. All right, that concludes the agenda. And unless there's any other business that we need to take up, we don't have a date yet for the next meeting. And frankly, I'm anticipating that we're going to need one and maybe more just because the session is so up in the air. We want to make sure that we're fully responsive and effective over there on behalf of the third branch. And so if this is, we're just following the procedures that we followed for years. And this is just how we get ready. But we may need to do some other things. I don't know. We'll just have to see. I'm in touch with the leadership over there about just logistics, and so is David, of course. And as things change, we'll just see what else we need to do. So we don't have a meeting yet, but we'll find out if we need one and try to poll you and get a workable time. Once again, it's nice seeing everyone, and thank you for all the hard work and your contributions. And of course, be careful and stay well.
Thank you, Chief.
We're adjourned.
Take care.
Thank you.
Thanks.
Bye.
Thank you. Thank you, Chief.
Thank you, Chief.